My name's Erin Nguyen-Neff. I'm a senior staff attorney at Disability Rights Education Defense Fund, also known as DREDF, since that's a really long name. So at DREDF, we work on a lot of different things to support people with disabilities. The areas that we focus the most on are health, education, and housing, among other things. For me personally, when it comes to litigation, I focus on litigation on behalf of students with disabilities and access to having proper education. And then also tenants facing disability discrimination and unhoused people with disabilities. Um, my presentation is focused specifically on how unhoused people with disabilities can request a reasonable accommodation under the ADA. We talk a little bit about shelters, but it's focused mostly on the experience of being in an encampment. So we'll cover a little bit background about the ADA, what is a reasonable accommodation, examples of reasonable accommodations, how to make a request, and what the process is afterward. And then at the end, if we have time, I have sort of a hypothetical situation that we can work on together to sort of just make sure the information soaks into your brain. And we'll have some time for questions too. All right, so what is the Americans with Disabilities Act, or the ADA? I'm sure people are sort of familiar with the broad strokes of it. It's federal legislation so it covers the entire country. A lot of states, including California, have their own sort of state version of the law. There are several different titles that are in the ADA, so focusing on employment, businesses, and stuff like that. For our purposes, we're really talking mostly about Title II. Title II regulates state and local governments and how they can treat people with disabilities. Title III is also somewhat relevant. This is related to what's referred to as public accommodations, which is essentially businesses that are open to the public. So restaurants, hotels, stuff like that. To the extent that sort of anything I talk about might be run by a nonprofit, like a shelter that's not run by the government, but run by a nonprofit, that would probably come under Title III, whereas anything that a government entity does will come under Title II. So what is discrimination under the ADA? The definition of discrimination under the ADA is a little bit more expansive, I would say, than the definitions of discrimination when it comes to other protected classes like race or gender, because there's sort of an understanding that there are inherent obstacles in our society to people with disabilities. So it's not merely just saying, oh, we don't discriminate against people with disabilities, but it's removing those barriers, right? So if like steps to a building don't necessarily sort of in an affirmative, active way discriminate against someone, but with a person with a wheelchair, they can't use that building, right? So that obstacle needs to be removed. So disability discrimination includes being excluded from participating in benefits, whether that be physical exclusion or the resources and services are not accessible, being denied any benefits that the government's providing because of your disability. If the services you're receiving are unequal or ineffective or segregated, if a person with a disability has to use a different application to get services that is not accommodating their disability, but is treating them differently. Operating services in a discriminatory manner, selecting inaccessible facilities, sites, and locations. So any sort of government service, when they're opening up shop in a new building, it should be accessible to people with disabilities. Those accessibility features, again, like ramps, wide doors, that needs to be maintained over time. Any sort of discriminatory eligibility criteria. So this could be, you're applying for a public benefit, and maybe the public benefit requires that you take an eye exam, but seeing adequately is not necessary for obtaining that benefit or using that benefit. So an eye exam is really discriminatory against people who might have a visual impairment. And also the failure to provide effective communication, which we'll go over a little bit more in a little bit. So the main thing we're talking about today is a reasonable accommodation, and specifically in the context of an encampment clearing. So what is a reasonable accommodation? One thing to know is that a reasonable accommodation in the context of the ADA is sometimes also referred to as a reasonable modification. So if you're talking about the ADA, either sort of word is fine. In other legal contexts, reasonable modification means something different. I won't get into it so as to not confuse people, but just sort of keep in mind that distinction. So in fair housing, when people are talking about discrimination in housing, that is usually the terms are used differently. But in the context of the ADA, they're used the same. So it essentially means changing a practice, changing a government practice, changing a government policy so that a person with a disability can take advantage of that policy or practice and their needs as a person with a disability are met. So we'll go into more examples, but the most common example of this in the context of an encampment would be, a person is in a wheelchair. They received a 24-hour notice that an encampment is going to be cleared. They can't move their belongings in 24 hours because of their mobility limitations. So they ask for a reasonable accommodation for 48 hours to move because they're able to do that with their disability. So that would be sort of like a basic example. And this applies to pretty much any government activity. The language used in the ADA is sort of like benefits and services, but it's very broad. So it doesn't necessarily even have to be something positive. So like if an encampment sweep, for people experiencing the encampment sweep, that's not a positive thing. That's not, might not be perceived as something helping that person, but it's still covered on the ADA, as well as police activity, city laws, health and safety regulations. So a person with a disability can ask that a health and safety regulation can be applied to them differently because of their disability. It applies to any sort of outreach workers, social workers that the government might employ. And it applies to both sanctioned encampments or safe parking sites, places where unhoused people are allowed to be by the government, as well as places that unhoused people are technically not allowed to be. Another thing is that it is an affirmative obligation. So what we mean by that is that it's not up to a government entity's discretion. If someone asks for a reasonable accommodation and it's reasonable and there's no issues with it, then they must grant it. They can't say like, okay, well, we've taken into consideration and we've just chosen not to do it. It's not discretionary. It's also the case that if a person's disability is obvious, then the government should really be asking them if they need a reasonable accommodation. So again, if someone's in a wheelchair, if someone's blind and has a cane, I would also argue, if you see someone having a panic attack, it's not just physical disabilities, it's also mental health disabilities. So if you see someone having a panic attack, that could be an obvious indicator of a disability. So in that situation, the government really has an affirmative obligation to see if someone needs a reasonable accommodation. Here are some more examples. So as I mentioned, more time to move, assistance with moving items. So, the government, police officers are often coming in to, unfortunately often destroy or throw away people's items. But you can, what they're supposed to legally be doing is storing the items. But you can ask for a reasonable accommodation to maybe move the items to a particular location that helps the person with the disability. Changing the time and manner of having to move an encampment. So, some cities have daytime camping bans where you can camp there at night, but you can't camp there in the day. Maybe that doesn't work with you as a person with a disability. You can't be moving your things because of physical limitations every day. So having an accommodation that you can stay there during the day. Special care for medical equipment and medication. Again, people are supposed to be, police should be storing people's personal possessions. It doesn't usually happen, but that's what they should be doing. But in a situation where they might store someone's wheelchair, well, can you asking for reasonable accommodation to, can you put the wheelchair in this location where my friend's at so I can get to my wheelchair later? requesting to stay in certain locations. So a lot of anti-camping laws will say something like, oh, you can't be within, 500 feet of critical infrastructure. You can't be within 500 feet of a commercial area. But maybe as a person with disability, you need to be there because it's near a doctor, it's near a treatment center, you can't travel far. You should be able to request a reasonable accommodation so that you can stay in that location despite the law. Um, Another, in San Rafael, in California, there was an anti-camping law that prohibited more than two people from camping together. And some people asked for a reasonable accommodation based on issues like having PTSD and needing to be near people for feeling safe, or having mobility limitations, so needing to stay at the camp while someone else like goes and gets food and other things that people need. So having an exception to the 2-person limit to allow 3 or 4 people in the camp because of their disability, which a court ended up ruling it was permissible as a reasonable accommodation. So effective communication, as I mentioned earlier, this is a little separate from reasonable accommodation, but I think also important to note under the ADA, there's also a requirement that the government effectively communicates with people. So this could include providing auxiliary aids. I think the most obvious example of this is if you're a person who's deaf or hard of hearing, you communicate with ASL or maybe a CART service. The government should be providing that so that they can effectively communicate to you. So, in the context of an encampment, if they're posting up signs saying an encampment's going to be cleared in 48 hours, and there's someone in the encampment who is blind, then that a police officer should be reading that notice to that person. Information on accessible services should also be provided. So if city employees are giving out information about shelters in the area, that should also include information about shelters that are accessible to people with disabilities. So when it comes to shelters, here are some examples of reasonable accommodations for shelters. One thing to keep in mind is that it also sort of depends on what is already provided. So, for example, we'll get into this a little bit more later, but if transportation is given from an encampment to a shelter, then that should be accessible to people with disabilities. But if transportation isn't provided, then asking for a reasonable accommodation for accessible transportation might not be considered reasonable. Obviously, most shelters are going to have bathrooms, so those bathrooms should be accessible to people with disabilities. Some shelter examples include allowing service animals or emotional support animals, even if the shelter has a no pet policy. I will say this gets a little bit tricky. Service animals are always allowed. There are some caveats with emotional support animals. I won't sort of go into too much detail about that now. It's because it kind of depends on what laws the shelter falls under, which sort of depends on how long people can stay at the shelter. If anyone has questions specific about emotional support animals in shelter, feel free to, email me. My email's at the end, and we can talk about that more at a different time. In a shelter, if there's a particular type of bedding that helps someone with their physical needs, if there are private rooms and someone has an anxiety disorder, doesn't want to be around people, that should be provided as a reasonable accommodation for a disability. Some shelters limit who you can come into the shelter with. Again, this, in some situations it might be okay, in some situations it might not, but in general, a reasonable accommodation to have an aide or a friend with you to provide support and personal care services should be an accommodation provided. And one thing to keep in mind is that there is an exception under the ADA for religious organizations. I'm not sure the historical context of that, but technically a shelter that's a Christian shelter, for example, can discriminate against people with disabilities. So there is an exception under the ADA for that. Um, So how to make a reasonable accommodation request. So there's no really one way to make it, and the ADA is designed for it to be a very low barrier of entry. If a person doesn't need to say reasonable accommodation, a person doesn't need to have it in writing. If they have a disability that they're making a request to alleviate that disability, that should be enough. But with that being said, I think using sort of best practices is, you might be more likely to get a reasonable accommodation granted. So I would say the first step would be to check if there is a reasonable accommodation process as part of your and there should be, like, every city government should have an ADA coordinator. So if you're helping an unhoused person, like, double check, what's the process to request an ADA or a reasonable accommodation in Santa Clara County. So who's the ADA coordinator? Is there an online form to fill out? Is there an email to send it to? With that being said, a request doesn't need to be made to an ADA coordinator. It could be made to any government entity, and it makes sense to target, whatever government entity you're going to be interacting with that as part of your request for reasonable accommodation. So, if it's a local police department that clears an encampment, it makes sense to, send a request to the police department, CC the ADA coordinator, CC any homeless services as well. Um, and there is no time limit to when you can ask for a reasonable accommodation, and there's no limit to the number of reasonable accommodations you can request. And even if a reasonable accommodation was rejected, that doesn't mean you can't make the same reasonable accommodation request again, because assuming it was rejected for the right reasons, your circumstances could change, and it might, be reasonable now. Obviously, maybe you don't have a physical limitation and you ask for a reasonable accommodation for more time to move. It was rejected, and then something happens, and now you do have some physical limitations related to your disability. You can make that request again. Each request should be considered on an individual basis and sort of considered with fresh eyes each time. Whoops. So the information you should include in your request, your name, how to contact you. If you're an unhoused person, it can really be any sort of means of contacting you: phone, email, social media accounts, messaging apps. I think it's helpful to include the location of your tent if you feel comfortable with that. If you are needing accommodation for more time to move, it would be helpful for people to know the location of your tent. Um, you don't have to make, as an unhoused person, you don't have to make the request yourself. Someone can make it for you. It could be anyone. It could be a friend. It could be a social worker. You want to, the sort of most important things to include is explaining that you're a person with a disability. You don't need to give an exact diagnosis or a lot of detail. You can basically sort of explain what the symptoms of your disability are, what the impact of your disability is, so that the kind of connection between your disability and the accommodation that you need, that you can make a connection between the two. So obviously, and then obviously you also wanted to describe the accommodation that you need. So for example, you might be a person with Parkinson's disease, and you are living in an encampment, and you need assistance moving your items because with your Parkinson's, you can't break down your tent and move it quickly. You don't have to say in your reasonable accommodation request, I have Parkinson's disease, if you're not comfortable with that. You can say, I have a disability. Because of my disability, I have limitations on physical mobility. So I cannot break down a tent and pack it up. So I'm asking for a reasonable accommodation for someone to help me do that. I think it's helpful, not required, but helpful to give a timeline and a specific date and time for response, especially in the context of an encampment. Things move very quickly. Sometimes you only get 24 hours notice. So saying, I'm making this request, please tell me by, close of business today, close of business tomorrow, what your response is. I think it's also helpful to include the context, right, of the request. So, um, I've received a notice that at this date, at this time, in this location, there will be an encampment sweep, and therefore I'm asking for such and such accommodation. Obviously, that makes it much easier for someone looking at the accommodation to act on that accommodation. If you just say like I say this, it might seem obvious, but I say this just because I have reviewed a lot of people's reasonable accommodations, and I think sort of like in the heat of the moment when there's anxiety is high and people are nervous and anxious about getting a notice to move their encampment, it can be easy to forget these things. So if you're emailing your reasonable accommodation request to someone who's not aware of the encampment clearing schedule, who's just sitting at a desk, who's not actively involved in the process, and you say, this is my name, I need more time to move. If they don't know the context, it's going to be hard for them to grant that accommodation. So including sort of the when and what context of your accommodation too. So here's an example. Dear ADA coordinator, my name is Quinn and I live at 50th and Broadway in a blue North Face tent. I have a physical disability and must use a wheelchair. My camp is scheduled to be cleared on February 5th, 2024. Because of my disability, I cannot move quickly, so I'd like to ask for a reasonable accommodation to have until February 7th, 2024 at 5 p.m. to move my camp. Please let me know by February 3rd if you will accept my request. Please contact me at this number. Um, excuse me. It's also really important to give details. So for example, I've seen requests where people say, I need 48 more hours to move my encampment. I think it's really helpful to say, I need by this date at this time. Because if you say 48 hours, you might not be on the same page with the person granting your request as to when the 48 hours start. Is it 48 hours from the end of the original notice period that a police officer gave you? So if they gave you 24 hours, is it 48 hours in addition to that? Is it 48 hours from the point in time that your reasonable accommodation was granted? That it might not be clear if someone says, yes, you have 48 hours, what exactly that means. So I think a specific date and time can be really helpful. So here's some tips when making a request. And I will say that, I, as a lawyer, some of these tips come from, because maybe I might want to sue somebody if a person's rights are being violated. But it's important to keep records of all of your requests. And I think, again, you can make the request verbally, but I think it's also helpful to have it in writing. Keep all emails, keep everything in writing. Note who you made the request to and who responded. The person who responds might be a different person. I think if you're helping an unhoused person, it could be helpful to tape the request to the tent. You might have sent an email and no one ever looked at the email, and someone's coming by to sweep. Tape that request onto your tent. Make the request as soon as possible. As I mentioned before, be specific about what you need and not vague. And you can always have a friend or someone make the request for you. So what happens after you make a request? So the city worker, city government should be making a fact-specific investigation that is particular to that person. So again, what that means is maybe someone made the exact same request, but that was denied. That doesn't mean it should be denied for someone making the exact same request who's a different person, because their disability might be different, their situation might be different. So it should be a very sort of fact-specific, individualized assessment. The city may engage in the interactive process. What the interactive process means is essentially when a reasonable accommodation request is made, there should be a back and forth with the government entity and the unhoused person to arrive at a solution together. Now, I write may because it's not legally required. I think it's what makes the most sense to do. It is legally required in other parts of the ADA, like under when it comes to employment and disability discrimination, for example. But with that being said, even though it's not required to engage in the interactive process, that doesn't mean, again, that someone can just say no. They still have some other obligations too. So even if they cannot make the specific accommodation that you requested, there should be an effort to look for alternatives. Um, so, for example, if you're saying, can you please give me a reasonable accommodation to have a private room in a shelter? Well, maybe there aren't any private rooms, so you can't say yes to that, but maybe you can give them, a bed that's in the corner of a larger room, so you're not near as many people, and that might work for that person. So you're not saying yes to the accommodation, but you are looking for alternatives to help alleviate that person's disability. As part of the process, you might be asked for proof of your disability. Obviously, as an unhoused person, that could be harder to come by. The idea is that the barrier for proof should be relatively low. The idea is that we want to help people under the law. So it doesn't necessarily have to be a doctor's note or medical documentation. It could be a social worker attesting to it. You can show like, oh, I have prescriptions, I have this medication, and if a person's disability is obvious, again, like if they are in a wheelchair, if they are using sign language, if they're having a panic attack, then the documentation should not be required. Okay, so what instances can reasonable accommodation requests be rejected? So, as I said, the government has an affirmative obligation, but that, unfortunately, that there are situations in which the government can say no. So one, if the term is reasonable accommodation, if the request might be considered unreasonable. So it doesn't, it's not actually helping you alleviate your disability, or maybe it's far more than what you would need to alleviate your disability. So for example, like requesting 6 months to move a camp as opposed to maybe like a few days or a week, that might be considered unreasonable. If you're a person in a wheelchair and you need more time, the odds are you probably don't need 6 months. So that might be considered unreasonable. Of course, again, because it's an individualized assessment, there might be a situation where you could argue that 6 months is warranted. Maybe you just had surgery and you're meant to be on bed rest for a long time. Can I have that time to stay in one spot before being moved? Maybe that's 6 months. So again, it's a case by case basis. Um, if the request is either fundamentally changes the service being provided, fundamentally alters it, or is an undue financial burden, then it can also be rejected. So for example, here, if you request regular therapy services as part of a shelter, but the only service that the shelter really provides is like a safe place to sleep, a cover over your head. That is likely to be considered a fundamental alteration of the service because they don't provide mental health services. You're requesting them to provide mental health services. In that situation, if you request like, because of my medication, I get cold, uh, very easily. There are temperature side effects to some medication. Then, if everyone's allocated one blanket, I would like a reasonable accommodation for 3 blankets. That would be a reasonable accommodation and not a fundamental alteration. And then if something's an undue financial burden, so that is, to use the same example, something like therapy services would probably cost a lot of money, especially if you're serving a lot of people. So in that situation, if a shelter's operating budget is 5 million and providing therapy services would, be an additional 2 million, that might be an undue burden for that shelter. Similarly to a reasonable accommodation request, like that, when determining if something is an undue burden, um, that should also sort of be a case by case basis, looking at what are the financials of the government entity, and that decision should be coming down from like the head of an entity. So, if it's just sort of your run of the mill rank and file worker, at a shelter says like, oh, we can't do that. That's an undue financial burden. That's really not enough to show that it's an undue financial burden. The other thing too is if a person or if the accommodation or the person is a direct threat to the health and safety of others. And we'll go into that more. Um, I'm going to skip this slide and come back to it so we can talk about direct threat, I think is the next slide. Whoops. My slides aren't advancing. So direct threat to health and safety. So, this might be a situation where, one situation used sometimes with service animals if there is like a history. I mean, this is rarely ever the case, right? But just as a means of an example, if there's a history of that dog being like violent and attacking people, obviously having that dog in a premises could be a direct threat to someone's health and safety. But the things to keep in mind when considering whether there is a direct threat is that it can't be based on stereotypes or assumptions. It needs to be an individualized assessment of that person based on current medical knowledge. So the most obvious example of this is that, I think a lot of people assume that unhoused people, particularly unhoused people with mental health disorders, are dangerous, right? So a lot of people think of like a person that they assume has schizophrenia who might be yelling outside of a shelter. The question is what's actually going on here? Has this person ever been violent to someone, ever physically assaulted someone, or do they just yell sometimes? They're probably not going to be a direct threat if there's no history of that, or if any history of that is really old. Maybe they did physically assault someone at some point, but that was 5 years ago. So you want to look at the likelihood of harm, the type of harm that would occur, and the severity of that. So if someone's just yelling at people, that's not a deep risk to someone's health and safety. The other thing too is if a second reasonable accommodation would remove that risk, then the person isn't a threat to health and safety. So, if someone has a mental health disability where they might get agitated in certain situations, that could trigger a more aggressive response, a physical response. Maybe allowing them to camp in a location where they're not around as many people, where they would be subject to those triggers, or to sleep in a part of a shelter where they're not going to be subject to those triggers. If that is possible, then that reasonable accommodation should be provided, and then the original reasonable accommodation should also be provided. So to go back to some more tips, one thing I want to make clear that I think people get tripped up on sometimes, again, it's just sort of this idea that in some situations something can be reasonable, and in other situations that they're not. So when it comes to the request, as opposed to the individual characteristics of the person, you need to look at what is the benefit that the person's trying to obtain, um, and how the reasonable accommodation sort of fits into that benefit. So, for example, we have example 1, Purple City provides portable toilets at a sanctioned encampment for unhoused people. A person asks them for a larger portable toilet that is accessible to people with wheelchairs. This is likely a valid request because the benefit that this person wants to use are these toilets that are being provided by the city that are not accessible. And they want to be able to use these toilets, so they're making a reasonable accommodation for accessible toilets. And the city is already providing those toilets. Now, in example 2, Orange City does not provide bathrooms or any services for people living in an encampment. And the same request is being made. A person asks for a reasonable accommodation for an accessible bathroom. This is likely would be considered an invalid request, an unreasonable request, because it gets to that fundamental alteration. In example 2, the city doesn't provide bathrooms. They don't provide any other services. So requesting an accessible bathroom is probably going to be considered sort of a fundamental alteration. It's not a benefit that anyone else in the camp has having a bathroom. So asking for an accessible bathroom doesn't quite fit into what's a proper reasonable accommodation request. However, with that being said, that doesn't mean you shouldn't ask for it per se. With doing this training, I was sort of explaining to people what are sort of the limitations and confines of the law. But that doesn't necessarily mean that you should limit yourself to that. And I say that to say you could ask for an accessible bathroom, and it could be that a city doesn't have to give it to you, but they might still give it to you. So it doesn't really hurt to ask in a situation like that. I have worked with people who that very thing has happened. There was an encampment, there were no bathrooms, they asked for bathrooms and they got bathrooms. So I say that to say, if you ask it as part of a reasonable accommodation and they say no, that's you might not necessarily have legal recourse to that, but it doesn't hurt you at all to also ask for it. Okay, so I kind of want to do a time check before going into the hypothetical and questions, since Tricia still needs to go. How much more time should I take up?
I think you can do like 15 minutes more. Is that okay?
Sure. So I think answering questions are probably a little bit more important than doing the hypothetical. And then if we still have time, I'll do the hypothetical. So, I don't know if I'll be able to see people asking questions. But do people have any questions? Feel free to,
I'm not sure
is
if
there-
that question was asked earlier. Are we going to get copies of the information?
I assume so.
Thank you.
Yes, we'll post it on the CoC SPN listserv, and it will be on the Office of Supportive Housing Training website.
Thank you so much.
Are there any other questions, or we can go into the hypothetical?
I have a quick question, and I'm sorry if this
Yeah.
is too broad. I've worked with a couple of clients in the past who have been diagnosed with both PTSD or some form of anxiety, and because of that, they're unable to stay in the shelters. They've connected with shelters before, and the shelters have kind of told them that it's going to be the group environment, and they're unable to provide them with like a private room or something like that. Is there any other way they can navigate that, or is that just kind of the end of the road in that instance?
Well, I would say like looking into like other alternatives other than a private room. So if it is, a large space, like can they get the corner of that room, and would that help the person? Can they put up dividers? So again, we talk about something being an undue financial burden. Like, getting kind of a simple space divider, like a like where you see with like wardrobes or something like that, or sort of like a cubicle. That, I'm sure you can find ones that aren't too expensive that could be used. It might, that might not be enough for your client. But I would try to explore other potential alternatives. And then I think it also warrants sort of an assessment of the space, because I think sometimes people say like that they don't have something, but if they're thinking more creatively, they can still develop it. But I do think, sort of like at the end of the day, if the shelter is sort of like a large gym space and it's just that and just bathrooms, like they can't like build out private space. So that would, requesting that wouldn't be a reasonable accommodation. But again, I think it's about like exploring other alternatives and, like, can I have the corner of this room and make sure that none of the other beds are within like 10 feet of that corner or something like that, I think could be reasonable.
Okay, thank you so much.
You're welcome. Any other questions? Okay, let's go into this hypothetical. Um, Jeremy is unhoused, visually impaired, and moves around with a wheelchair. A police officer hands him a notice that says the encampment will be cleared in 48 hours. Jeremy asks what the notice says, but the police officer ignores him. A friend tells him the encampment is being cleared. He asks another police officer for more time to move and if a wheelchair accessible van could pick him up to go to a shelter. The officer asks for a doctor's note or other documentation of his disability. Jeremy doesn't have any documentation. The officer says he doesn't have the power to grant the request without that documentation. So the question is, what are Chris's rights in this situation, if any? Is there a potential violation of the ADA? And how would you proceed in helping or supporting Chris? So I don't know if I don't think I can see the chat while sharing. Or can I see the chat while I feel like I've
If
looked
you
at,
hit the chat button, I think you're able to see it. Does it come up on your screen?
yeah, I don't see a chat. I feel like I've looked at chat buttons before. Has well, it's just if people can put in the chat, maybe first, like listing, if Chris's rights have been violated, and if so, what examples in that hypothetical would you say that's a violation of his rights? And then maybe the chat, are people putting things in the chat? Because I think sometimes it pops up if people are chatting.
Not yet. And we can flag it for you if anyone puts anything in the chat.
Yeah, so what are some of the things that you all see as a potential violation? And also if someone wants to like come off mute and just say it instead of putting it in the chat, you can do that too. Oh, I see the chat now.
Okay.
Okay, great. So Karina says unwillingness to explain the notice. Yes, that is definitely one. Because he's blind, that goes back to the effective communication. He's blind, he can't read the notice, so that should have been explained to him verbally or given to him in a way that he could understand. Thank you, Olivia. Yes, thank you, Danya. That the asking for documentation despite Chris being in a wheelchair. Yes, so it's he obviously has a disability, so he doesn't need to provide documentation. And one of the reasons why I put that in is that, I've noticed in talking to a lot of people, sometimes the city will respond in a way as if, their hands are tied, like this is just how it is. So that's why I kind of like worded it that way. And the police officer responding like as if like they would help if they could, but they just can't because they don't have this documentation, but they don't need the documentation. Any other violations that people see?
I have a question,
Yeah.
or I don't even know if that's a question for here, but, or if, say, a client has severe mental health and has episodes. So the client has these episodes, it's already been medically diagnosed. He's already been medically diagnosed, and he's in a tiny house. And he gets kicked out because he's having an episode and they don't know what to do. What are his rights in that situation? And since that situation, he's just gone on a downward spiral.
Yeah, that's a good question. So, I mean, so when you say episode, do you mean like he's acting violently toward people or?
No, just towards himself
Oh, towards himself.
within his tiny house.
So I mean, I would say that in that situation, that he, because he's not being a threat to other people, that
Mhm.
he shouldn't be like kicked out of that tiny house.
Right.
And that, if he's having these episodes, the people running the tiny house have an obligation to try to see if there's a reasonable accommodation that could help him stably be in that home. So what are triggering these episodes? What sort of support might be able to be provided to stop the episodes? Again,
Mhm.
it could go a little bit into like, does it become a fundamental alteration? Like maybe he really needs a therapist, but the only thing being provided is shelter in the form of these tiny homes.
Mhm.
Um, but with that being said, there's still an affirmative obligation to try to provide a reasonable accommodation that isn't a fundamental alteration or an undue financial burden. So I think that necessitates figuring out what's triggering those episodes and what can be done within those confines.
Mhm.
I do think it's a very, very difficult situation. Um,
Mm.
and unfortunately, a lot of it comes down to there's usually just not enough resources and funding to help people with such a serious situation. But I don't think that a person who's only harming themselves should be kicked out of like a tiny home.
Yeah.
I think unfortunately that people worry about legal liability in that situation, right? And that goes sort of beyond the ADA, but might still be disability discrimination. I think people worry about, if you know that a person is suicidal or hurts themselves and they
Mhm.
do it on your property and you don't do anything for it, is someone going to like later sue you for wrongful death or something like that? I think
Right.
that's sometimes a reason why people want to kick people out. Obviously, that's still a very inhumane way of treating
Right.
someone. And, I would argue that that is a form of disability discrimination too. Um,
Yeah.
that it's a little bit different from the reasonable accommodation, but in the other forms of discrimination we talked about in the beginning, I think to treat people who harm themselves differently by kicking them out versus people who don't harm themselves when harming themselves is part, is a manifestation of their disability, that could potentially be disability discrimination too.
Right. Yeah. So yeah, since then he's been beat and jumped and just several experiences that's occurred since then. From what I understand, the director did get fired, but I don't know where to send him to reach out for further services for like he wants to talk to a lawyer, but I don't know where to send him. I don't know. Is there something at the end of this training that
I not to put Tristy on the spot, but because I think Law Foundation might have more referrals in Santa Clara County since they're based in there that might be able to help with that particular situation. Um,
okay.
I don't know for Santa Clara County off the top of my head.
Yeah, okay, so you said trusted law, what did you say?
Oh, Tristia, who's presenting first and is going to present again, might the Law Foundation of Silicon Valley
Oh, Law
might have some
Foundation.
resources or referrals too.
Yeah, that's who I was gonna refer, Law Foundation, because I don't know any other place that I could refer them to. Okay, well, thank you very much.
Thank you. And then I see two, we've seen that in supportive housing where a client cannot stop screaming around midnight or reading loudly or more likely to
Mhm.
get evicted. Um, just to touch on that, like that is, you know, I used to do eviction defense and I represented people in those cases and it is very difficult. I think, I will say, that, uh, although I'll say in most of the cases I worked on, it was like a private landlord. It was not supportive housing. I think in supportive housing that's being run by a city entity, again, like they should be taking into consideration, is there, a reasonable accommodation that might help mitigate that behavior? Um, and it's hard again, like at the end of the day, like being loud and screaming is not a direct threat to someone's health and safety. But I think oftentimes in situations like that, people are signing contracts, signing lease agreements, probably where they're agreeing that they're not going to do that. And if they do, it can lead to evictions. And I know sometimes there can be very strict rules in supportive housing, which then kind of like brings in other laws aside from the ADA, like for housing laws, private contract laws. So it's hard for me to speak to that with sort of without knowing like the individual situation, the facts. But what I'll say is that in a situation where a person with a disability is being loud and they receive an eviction notice, what I would suggest doing in that situation is one, particularly if it's a notice to perform covenants or quit, which is usually something where I might be like, you're doing this, you have 3 days to stop doing it. Is to ask for a reasonable accommodation for more time. If you're screaming as part of your disability and you need help to figure out how to stop doing that, that's going to take time. So I'd always ask for a reasonable accommodation for more time. When you should almost always get a notice before an eviction. Before an eviction is filed. So asking for a reasonable accommodation to extend that time. And that might, there's no easy solutions to this, but that might give that client more time to get access to resources, to get help, to try to have an understanding of why they shouldn't be screaming. Because if they're only getting like a 3-day notice or something like that, they're probably not going to be able to come to any solution in that time. So asking for a reasonable accommodation for more time. If an unlawful detainer is filed, you can ask for a reasonable accommodation to rescind that unlawful detainer, to extend the time for that too. And then looking and exploring if, what can be done aside from getting more time, to try to alleviate that behavior, and does that necessitate a reasonable accommodation? Um, I think, maybe I have like 2 more minutes or something in my 10 minutes. So I'll just real quickly kind of go through some of the issues that were in this hypothetical so people know. So everything people have written in the chat is correct. One thing that was, did anyone pick up on the one misdirect that I put in the hypothetical? So one thing that Jeremy asked for that is not legally required. So, in addition to, asking to have the notice explained, stuff like that, he asked for a wheelchair accessible van to pick him up. The question in this situation would be, does the government provide transportation to shelters? If they do not, requesting a reasonable accommodation for a wheelchair accessible van, might not be a reasonable accommodation, since that's not a service already provided by the city. It could be considered a fundamental alteration. Again, it's still worth asking. But if the city worker, the police officer says no to that particular request because no one receives transportation, then that's likely not a violation of the ADA. Okay, I just wanted to point out that one thing, and I will end there and pass it to Tristia.
Thank you, Erin. I appreciate that. And thanks for going first and providing so much helpful information and context. We heard what the law is and what the process is and best practices for requesting reasonable accommodations. And due to technical difficulties that I partially solved, you missed some of the context that I was hoping to give. So my part of the presentation is intended really to be context for how and when we would leverage the law and where to go beyond the law. The law sets a floor, and those are the rules that bind government actions or that enable advocates to ask for accommodations on behalf of people with disabilities. But a healthy society is one where we care for our most vulnerable members, and certainly people who are unhoused, struggling for survival, and living with disabilities are some of our most vulnerable members. And when we think about what types of accommodations people need, I think it's always helpful to have context, because ultimately, as you heard Erin describe, it comes down to an individualized assessment of that person's need. And, it requires us to use our utmost creativity to think about what could, within the confines of the law, and our intent, be offered to accommodate that person such that they can maintain health and safety. So again, and I'll go through some of the initial slides quickly, because taking a look at the folks who are in the room, my guess is that you're familiar with a lot of this. But again, my name's Tristia Bauman. I am the Directing Attorney of Housing at the Law Foundation of Silicon Valley, based here in Santa Clara County. Next slide, please. So we talked, very briefly at the beginning, why are people unhoused? It's because we have a massive affordable housing gap. It is not a colorblind gap. It affects people differently based on their race and other identities. And we'll see that reflected in the unhoused population. But it's important to keep in mind, we have a housing crisis that's contributing to a homelessness crisis. Next slide, please. We talked before about the gap, and I think it's worth just reiterating. Nationwide, 33 for every 100 extremely low income households, meaning about 3 for every 10 households. There are 3 affordable and accessible units for every 10 extremely low income households. And that amounts to about a 7.3 million unit gap nationwide. Here in Santa Clara County, we reflect the same numbers. There are only 3 affordable and accessible units for every 10 extremely low income households. So 7 of those households have absolutely no shot of being able to sustain the cost of housing. Next slide, please. And let's take a very quick look at, why that is. This is a wealthy area. We have a lot of, success. Why are we seeing so many people struggle in our county, reflecting, a nationwide trend? And it's because earned income growth in our county is creating and exacerbating a wealth gap. Those at the very top percentiles in earning are doing better since the year 2000. You can see increases of 14 and 16% between 2000 and 2019. During that same 19-year period, people at the lowest income percentiles lost ground, lost 8 and 7%. So as life becomes more and more expensive, and certainly we know in the last few years as a result of price gouging and inflation, housing and other goods and services have become more expensive. People who are our lowest income earners are losing ground and have less ability to pay for life's necessities. Next slide, please. Here's a slide that compares median rents, and this is nationwide, and this is 2001 data, and median rents have certainly risen since then. But what we see is a line that shows absolutely that the cost of housing is outpacing renters' ability to pay for housing. Nationwide, half of all renters are cost burdened, meaning they pay more than 30% of their total household income just on the cost of housing. Next slide, please. So, the result is that paying the rent each month is a struggle. If you can even find a place, and that is not going to be a given for a lot of our low-income households, sustaining housing and maintaining it is a struggle, and it's a struggle that you'll experience every month. And nationwide, as well as here in Santa Clara County, 7 of every 10 extremely low-income households are severely housing cost burdened. And that means that the people at the lowest end of our income are paying over 50% of their total household income just on the cost of housing. And that is how we define severe housing cost burden. But the reality is that many people are paying nearly 100% of their income on just rent and utilities every month. And of course, that's not sustainable. And this number shouldn't surprise you. If there are only 3 affordable and accessible units for every 10 households, the other 7 are left at constant risk of housing displacement and homelessness. Next slide, please. And we see that reflected in the data. So, this is the most recent national data reflected in the report that HUD makes to Congress every year, and the point in time count, which was just conducted locally for this year, and has been done nationwide and revealed a number of 771,480 people that were counted last year. What we see now is the highest number of people counted ever in the history of recording homelessness in the United States of America. We have now the highest number of people experiencing homelessness in recorded history. This number is also a dramatic undercount. It is generally considered to be at least a 2.5 times undercount of the true size of the population. Some of that reflects the methodology, who we count and who we miss. This large number of people, while it represents an 18% increase from the prior year, is less than the total number of people who are without stable housing in this country. And that true number is estimated to be as high as 3.5 million. Quickly, I'm sorry, back to the slide. I'm still on the data slide. The fastest growing population nationwide is also the fastest growing population here in our county. We see the national trends reflected here. Family homelessness has increased dramatically in Santa Clara County, and it has increased dramatically across the nation, a 39% increase from 1 year in family homelessness. And a lot of that is happening through eviction courts and through threats of eviction, because a majority of the people who are in unhoused families are people who were low-income renters. The largest increase, the demographic that experienced the largest increase in homelessness are kids, people under the age of 18. And there is a gross disproportionality in the impact on people with disabilities. 1 in 3 individuals who were counted in the point in time count reflected in this highest ever number in recorded history are people who are experiencing chronic homelessness. And that is defined in federal law as a person who has a disability and who has experienced homelessness either multiple times within a 3-year period or for a consecutive year period. So about 1/3 of people are chronically homeless and by definition have disabilities. And it's estimated that at least 40% of our unhoused population are people with disabilities. That's pursuant to the point in time count data. Other studies show that it's as high as 67%. And overall, for our total population of people, there are more who are unsheltered than sheltered. And what unsheltered means under federal definitions are people who are living in places not fit for human habitation, like in outdoor settings or in vehicles, rather than in emergency shelters and other temporary settings. Next slide, please. So let's take a look. We've talked a little bit about the cost of housing, a little bit about the demographics reflected in the national data, but let's zero in even more on people with disabilities. So in addition to disability increasing the likelihood that a person would experience poverty, people with disabling conditions have higher rates of poverty, perhaps as a function of their limitations on ability to work and the amount of income that they earn, or it can be a reflection of housing discrimination that they experience. It also, in addition to struggles with ability to pay, can be a barrier to housing access just by virtue of accessibility of the building. For example, if a building has stairs to enter or units that are available on floors that are, the second through higher floors, and they don't have adequately operational elevators, for example, and that is a common problem in our area, then those buildings are functionally inaccessible to many people with disabilities. Disability is not just a barrier to housing access, it's also a barrier to housing stability. And that is reflected in some of what we talked about in at the end of Erin's presentation. There was an audience member who talked about a person who was experiencing symptoms of their disability while in a tiny home, and is facing displacement from that tiny home by virtue of being symptomatic. We see that frequently in eviction court, people who are struggling to follow the lease terms or community rules because they will experience the symptoms of their disabilities and behave temporarily in ways that allegedly violate those terms or rules, and will be faced with eviction proceedings, which can move very quickly, and for which there are not nearly enough attorneys in this county and nationwide to assist people in preserving the housing that they have. Being unhoused, I'm sorry, go back. Being unhoused also increases the risk of disability in that homelessness creates illness. It elevates the risk of death. It makes it difficult to treat health conditions, and is a condition such that it allows people to become severely sick. It also subjects people to trauma and to chronic stress that can exacerbate conditions. And that's why we see people who are living without housing die 15 to 20 years earlier than people who have access to housing. Next slide, please. Well, knowing all that, then, why in the world are people living in public space? Why are they outside instead of living in shelters? And I just want us to, take a look at this image. I know that many people on this call are going to have some familiarity with, different forms of shelter, but what you see in this image is a fairly, typical view of a temporary congregate shelter. Next slide, please. So, so why are people living outside and not in shelters? Well, one reason is that emergency shelter is not housing, and it's really important that we understand emergency shelter for what it is, which is a crisis intervention that is necessary as part of a continuum of services to address homelessness as it exists. But it is not a solution to a lack of housing. Housing is the solution to being unhoused. And emergency shelter is not housing. So, that is a fundamental principle that I would ask all of us to keep in mind as we think about policy making and what reasonable accommodation requests can and should look like in the context of criminalization or displacement, or even temporary placements in emergency shelters. But even if there were enough emergency shelter, even if everyone outside had the ability to access emergency shelter, the infrastructure is not sufficient to allow for that. Excuse me. A more plain way of saying that is that there's not enough emergency shelter for even the people who are seeking it. They are full, routinely turn people away. We have waiting lists here, certainly in our county, and they can, depending on the composition of the household, be weeks long. And it's also a temporary setting. You are not able to live indefinitely in an emergency shelter until you have a permanent housing option available. It's a temporary option, and it can be in a distant location. For example, in South County, there are very few emergency shelter options. In Gilroy, with the highest per capita unhoused population, there is one emergency shelter, and if you are displaced by a sweep, you have 24 hours in the emergency shelter, which is the Armory, before you would be then required to go to a different shelter up in San Jose, which is a very distant location if you're living in South County. It also, in addition to being a temporary option, is one that can, be limiting on the ability to bring in property. And that's, just a function of how emergency shelters are set up. They're not warehouses equipped to handle the volume of property that people might want to bring in. But if you're only able to bring in a bag or two of property, that can be a functional barrier to entering into emergency shelter. And that may be particularly true for people with disabilities who, by virtue of the necessity of treating their disabilities or living with those disabilities, will have more personal property that may need to be with them and stored. Also, many shelters offer congregate settings, which may not be medically appropriate settings for people with certain medical vulnerabilities or mental health conditions. And as a result, shelters are not accessible to all people who live outside. There may be literal building barriers for people who are mobility impaired. For example, a person who is in a wheelchair may not be able to physically access a building where shelter is offered, or the bed that is being offered may not be available. In this image, you can see that there are some bunk beds. Top bunks, for example, may be functionally unavailable, even if empty, to people who have mobility issues or people of advanced age. In addition to, some of the other reasons why shelter may be inaccessible for people with disabilities. I'll just name medical vulnerabilities is an important one. And we saw that really clearly during the COVID-19 pandemic. Obviously, in any congregate setting of any type of human being, you're going to have, the potential for disease transmission. And for people who are immunocompromised, for example, or who have high risk of infection, or people who need to be able to control access to their medications, who are not allowed to do that because of the, setup of the emergency shelter, those settings can be functionally unavailable to them. Next slide, please. So, what does that mean? It means that people will, be left without housing, without access to indoor shelter or perhaps other indoor alternatives. And many of them will seek out community in an encampment because that's what human beings do. We're, a social species. And there are some benefits that to living in encampments that can benefit both people with disabilities and people without. In a community, there can be enhanced safety, better access to resources through shared resources. There's somebody around who can watch your property when you go to doctor's appointments, for example. And there may be encampments that are located in proximity to services that are needed, that human beings need, but that they otherwise wouldn't have access to, like, for example, public bathrooms or waterways, so that they can have access to toilets and to drinkable water to clean themselves. There may also be other practical reasons for the location of the encampment, like proximity to public transportation or available shade or shelter structures, which can be critical as you manage survival in whatever, whatever the weather has to offer you. Next slide, please. So, and the last setting I'll talk about is, why someone would live in a vehicle. This is going to apply to, people with or without disabilities, but it can be particularly important for people with disabilities because vehicles, particularly RVs, can offer a lot of the attributes of traditional housing. And in fact, RVs are considered an affordable housing option when they are in RV parks or mobile homes, but they are not considered part of the housing infrastructure when they're parked in public space, which I think is a policy matter that we need to change. But it is a reality that vehicles, in particular RVs, can offer attributes of traditional housing, like locking doors that allow for some amount of security, You can have access to electricity, which can be vital for temperature control. You can keep it warm or cool. Refrigeration, so you can store healthy foods or medications. Cooking facilities to be able to eat healthy foods, as well as electricity to charge medical devices or phones, which are critical lifelines for maintaining communication service relationships and access to information. In addition, RVs, for example, can offer access to running water, showers, functional toilets, and space to store critical property, medical equipment like oxygen machines, for example. Next slide, please. Now, we've just talked about why people don't have an option to live in traditional housing, some of the barriers that they experience in trying to access the temporary shelter settings, and some of the reasons why people would, good reasons, rational reasons why people would live in encampments or vehicles. And despite that reality, the policy response to unsheltered homelessness, which is, characteristic of our unhoused population. Remember, there are more people living without shelter than in shelter. The policy response across the country has been to punish homelessness and punish unhoused people for their presence or unavoidable activities in public space. When I was at the the Law Center, the National Homelessness Law Center, I published a series of reports that looked at 187 cities across the country, big and small, urban and rural, and tracked a rise in laws that target and punish life-sustaining activities of unhoused people. The most recent update is 2019, so obviously that is dated in data now. And so the data that we'll look really quickly at comes from that report. But if the trend continues as we expect that it has, based on what we've seen at the state level and just colloquial evidence, the numbers we're going to discuss here have only increased in recent years. Next slide, please. So in 2019, we found that nearly, 3 out of 4 cities prohibited camping outside, and camping can be broadly defined to include using a structure to shelter yourself. But we also see camping bans defined to include resting temporarily in place with any property. So that could be sitting down with a backpack. Next slide, please. Also, we found that over half of cities restrict literally the postures of sitting and lying down in public spaces. Obviously, no human being can resist sitting or lying down in public. In fact, many of us spend most of our days either sitting or lying down in public because no one can stand or remain in movement indefinitely. In fact, I guess everybody's sitting down right now, or perhaps lying down as they're listening to me. So, those are punished as crimes when you do it in public space, and they're enforced against people who don't have an option to be outside of public space. Also, and this is the fastest growing anti-homeless law, about 50% of cities restrict living in vehicles, and these types of restrictions take a variety of different shapes. They can be, pure bans on sheltering in vehicles, what we call vehicle habitation ordinances, or they may take the form of parking restrictions. And we're seeing a pilot program, the Olive program, here in San Jose, be enforced now, where there are 30 different areas and an estimated 900 occupied RVs that are being targeted for sweeps and towing and impoundment under parking enforcement regulations. Next slide, please. Okay, so this one is you'll have to scroll forward. And the point here is that I talked about, some different types of bans, but the activities that you see here, sorry, next, yeah, and you just arrow forward. The activities that you see here can be punished under a broad variety of laws. Unlawful camping, we talked about, sit-lie bans, keep going. Yeah, disorderly conduct. This is, can be, can run afoul of any of the laws that you see populating your screen, along with others. I've just named some of the most common. And, what you see here are activities that are truly unavoidable, and that people with disabilities are going to disproportionately perform because they are disproportionately members of our unhoused population. Next slide, please. So, let's talk a little bit about what enforcement looks like and how it can affect, again, everyone, but have an acutely harmful impact on people with disabilities. So, sweeps of encampments. The images that you see on this slide are of, people who are in the active process of being swept. And I'll tell you a little bit about their story because I know all these people. So in the context of encampment sweeps, you're generally going to see that they are conducted with little or no advance notice. Increasingly over the past decade or so, we are seeing more cities and governments engaged in sweeps provide some amount of advance notice. Typically, that's going to be about 72 hours, but 3 days to move your life from where it is to another location when you are not given insight into where you can move to, not provided immediately accessible options or assistance in getting into any of those other options, and preserving your property, which is generally going to be true of sweeps of encampments, creates massive hardships for able-bodied people, but can be even more onerous for people with disabilities. So, very little notice. When the notice is posted, the scramble begins, and part of that scramble is to preserve property. In fact, some of the surveying of unhoused people reveals that to many people's minds, the constant threat of loss of property is the greatest harm that they experience as a result of routine displacement. And displacement from public space is a function of what I call the criminalization of homelessness. And part of that is because people are displaced without a plan for where people can move to. So I talked about the new Olive program that is being implemented in San Jose. There is not a location where people are being directed to because there isn't a plan for where they can go. The idea is you can't be here. And that's going to typically be the case. There will be, displacement from the location where people are. Oftentimes in our area, although not always, a person may be given information about how to access our emergency services infrastructure, like, for example, be given the Here For You hotline number. And, again, very valuable service, important crisis intervention, but there are people who are going to need access to emergency services and not be able to get them because of waiting lists and other barriers that exist given the volume of human need and our lacking infrastructure. So as people are given short notice and they're trying to figure out where to go, they are also trying to pack and move their property. And that is physically taxing work. In addition to being very stressful work, that is physically taxing work, and not work that everyone can perform equally. Obviously, seniors, people who are very ill, people with mobility issues are going to struggle to, perform that type of work within a short period of time. And, we'll talk in a moment about why one of the most important reasonable accommodations is to offer more time to people who will need more time based on their disability. And, just one story very quickly, the woman that you see featured here, and I took this from a newspaper article, and she agreed to have that image taken. She is now the head, one of the founders of the Gilroy Homeless Union. She's also been swept multiple times. Luckily and gratefully is currently housed, but it takes a very long time to go through a process, a period of months, and she was swept multiple times in the time that I knew her. from the low outdoor home where she lived during the period of time when she was waiting to be placed in permanent supportive housing. And one of the sweeps, because she is a person with disabilities, as is her partner, was so physically taxing because they have to, physically pack things into the materials that they can gather, and then with a bicycle take them to their storage location or to the next location where they'll be. Her partner ended up in the hospital with pneumonia. And, that's a reality and an example of just how difficult it can be and how vulnerable people with disabilities are during displacements. In addition, there can be loss of property. So, it is common that people will be deprived of whatever property they can't carry away prior to that 72-hour period. And sometimes if there's no notice, or if they're not present at the time that a sweep starts, for whatever reason, they're at work, they are at a meal service, they're at the doctor, their property may be just summarily trashed. And even if it's stored, the majority of property is not returned to people. And that can result in the permanent loss of medicine, ID, and paperwork in order to get the type of services that are necessary for anyone, but, particularly important for people who are treating their disabilities, loss of medical equipment, clothing and bedding that is necessary to keep people healthy, food, as well as the loss of their shelter. Additionally, and I really want to underscore this, it is traumatizing, it's scary. Even I'll speak for myself, having been present at different sweeps. It is an intimidating situation, even if you're not the subject of a sweep, to see so many people with authority come and order you to leave. And that type of trauma also can exacerbate can exacerbate disabilities. And of course, displacement can interrupt service relationships and other relationships. It can make it more difficult for people to become housed and to remain healthy and safe. Next slide, please. So I'll go a little more quickly, just, given the time. But, tows of vehicle homes happen in really similar ways. And, in many instances, tows happen with even less notice. It could literally be what Jess Bruder, who is the writer of Nomadland, what she described as the knock. People in vehicles live in constant fear of a knock. You are illegally parked, or you're not registered, or you have been here for longer than 72 hours. The tow truck is going to imminently come. And that can be the permanent deprivation of what might be your form of transportation, in addition to your shelter and place where you store all of your property. Even when, as is the case with the Olive program, you have a longer period of notice, like, for example, a week after the no parking sign goes up, there aren't places where people can move their vehicles to. And when a person who is occupying an RV, for example, because it is most appropriate, because they can afford it, and because it's most appropriate for management of their disabilities, they're going to have a really hard time finding locations where they can park, because outdoor public space locations are more restrictive because there are more restrictions on large vehicles parking in public space than on passenger vehicles. Also, there are limitations on access to RV parks. For example, many RV parks require vehicles to be no older than 10 or 15 years old in order to enter the park. There are too few programs that are designed for large vehicles. So, for example, the Safe Lot model, and that can be a fabulous model, is often operated on an overnight only basis, where somebody comes in at night and then has to leave in the morning. That's just not appropriate for people in large vehicles for a variety of reasons, including because it's expensive and difficult to navigate large vehicles in and out of those lots. And what that can result in is ultimately people having their vehicles towed and impounded and being fined, for the storage of their vehicles. And ultimately, we all pay the price. There's a great report if you're interested in this, that was you can find it on the Western Center on Law and Poverty's website, that talks about the loss and taxpayer burden that we all face as a result of towing and impounding people's vehicles through poverty tows. And that includes towing and impoundment of inhabited vehicles like the RVs that you see here. And of course, it can result in family separation as well, because many people living in vehicles are not living there alone. Next slide, please. There are ways to challenge these types of restrictions. And so, reasonable accommodations and finding ways to accommodate the needs of people can be not only an immediate benefit to the person who needs that accommodation, but it also can be a benefit to everyone because, class action litigation is expensive, time consuming, and, ultimately it costs taxpayers, but sometimes it becomes necessary. So, very briefly, the a class, and this is a case that resolved recently, that was filed by Disability Rights California, and and also the Law Center. While I was there, we brought it here to the Law Foundation for resolution of this case. But it was a class action against the city of San Diego that made it illegal to live in a vehicle anywhere in the city of San Diego and to park an oversized vehicle overnight in the city of San Diego. The person that you see pictured in this image is Michael Bloom, who is the lead plaintiff in that class action, who unfortunately didn't get relief before he passed away in the vehicle that you see featured there. The claims in this case included a variety of different constitutional claims, but we also raised disability discrimination under the ADA in Section 504. The city of San Diego moved to dismiss our ADA claims, and we were able to defeat that motion to dismiss because the court found that we had stated a plausible claim of disability discrimination through enforcement of the vehicle habitation ordinance and the oversized vehicle parking ordinance against people with disabilities. Ultimately, this case settled, and we got the largest negotiated package of relief in this type of case that has been seen across the nation. Massive ticket forgiveness, relief from enforcement, additional safe parking options, as well as parking improvements, and monetary damages for our class members and monetary damages for the representative plaintiffs, and a 3-year monitoring period. But that is not something that is a solution. Next slide, please. What we want to do is to accommodate people such that type of litigation and monitoring, which is very expensive, certainly for the city of San Diego, we want them to be able to grant accommodations to people when they need them. So, very quickly, we talked a little bit about like the circumstances that people are facing. And Erin talked about, what the law, is likely to require and what it may not require, because, you cannot ask for things that are unreasonable or that are unduly expensive, or that would be, a fundamental alteration of a program. But I would encourage people to, to really think about the types of accommodations that people need and to request them and to engage in the interactive process when it's offered, to think really creatively about ways that people can be accommodated to reduce their risk of harm. One of the low-hanging fruits, of course, is more time to comply with the notice. People are expected to move really quickly when they're asked to move, and they don't have places to go, and they don't have assistance packing, and they don't have assistance with where they're going to put their stuff or keep their animals or keep their families together. And they're going to need more time when when, particularly when they are people with disabilities. And it should be individually tailored. A person who has, cognitive disabilities and struggles to manage complex tasks, especially in stressful conditions, is going to need time that's appropriate for that individual. A person who is mobility impaired may need a different amount of time. So these requests should be individually tailored. It is also, a good idea to ask for an assessment opportunity to meet with a service provider before displacement. This may fall into that gray area of we don't have to, but these would be helpful things and things that are worth asking for, particularly when the disability is known or should be known to those enforcing the sweep of encampment or the tow and impoundment of a vehicle. Another thing to ask for, and this is certainly going to be in the gray area, but an opportunity to remain in place until a person can be permanently housed or until an appropriate setting that is immediately and accessible to them can be identified. Again, it'll really depend on the circumstances. A person who's never had a VI SPDAT done, who would need to go through the entire process of seeking housing through the Office of Supportive Housing, is not likely to have that accommodation made. But perhaps that type of accommodation is something that could be negotiated on behalf of a person who, has gone through, many months of the Office of Supportive Housing process, has now been approved for, a particular building, and is just waiting on approval of the housing subsidy, for example, and something that that might take lesser time. So that's another type of accommodation that you could ask for. You can also ask for information about accessible and immediately available locations. Oftentimes people are given, like from Beautify San Jose, people are given kind of a generic flyer, and it has a QR code and it has a phone number, but there's nothing that describes where is actually available and where might be accessible. So, individualized analyses can lead to individually tailored offers of alternative locations where people can be. You can ask for assistance with transportation to that location. If nothing like that is ever offered, you'll probably get denied, but it is worth asking. And in some instances where you can point to other examples of transportation assistance where perhaps arguably it's not a fundamental alteration of the programs offered by that particular city, then it could be something that may be required, and of course that's fact specific. People are going to need assistance with packing and physically moving. So in addition to all of us helping and recruiting people to help, because that is such an important help, seeing if there is any assistance. For example, in the city of Gilroy, they will, as a city, offer certain packing materials, which can be helpful. Like, for example, they will offer bags to people. You can also ask about ability to maintain your service or emotional support animals with you, along with the things that you need in order to maintain your animal. Like, for example, to keep the food that you use to feed them, or to keep the equipment that's necessary in order to keep them. And you can also ask for the ability to retain other types of property without it being stored, or to get really quick access to it if it does ultimately get removed. And that can include, as low-hanging fruit, things like medical equipment, medicine, shelters, if they're stored. Usually they're not, and warm clothing or other items that are necessary for health and safety. Next slide, please. It's going to look, similar for accommodating people in vehicles. and I've added just a couple things to this particular slide. You know, as you are talking with people, let them know that they do have a right to request a reasonable accommodation. Erin gave some great guidance as to what to say. There's no magic words, and it is always beneficial to officially request it for a variety of reasons, and to ask for specifically what it is that you need. You can also encourage people to ask for a process for reviewing and rendering decisions prior to an adverse action, so prior to a sweep or prior to a tow, and asking, government to engage in an interactive process if the accommodation request is declined as you've requested it. You can also ask for there to be no adverse action until an individualized assessment has been made of a person's disability needs and what accommodations can be made for them in the existing infrastructure. Now, all of these things may be from some people's perspectives, Hail Marys, and maybe they are, but it can be useful, in my view, to request them and to advise people to request them because it can encourage interaction, which can lead to more meaningful interactive processes. It also could, potentially over a longer term lead to better policies and programs that are offered by the various communities that we live in. And then, of course, there are others that are almost certainly outside of, what cities typically, or I'm going to say cities to mean, community that's enforcing it, but going to be county or state. Usually they're not going to provide assistance with relocating items or repairing or relocating vehicles, but perhaps they will. And even if they don't, you can ask for more time to get that assistance privately. For example, some of the people who were swept from Chenoweth pursuant to the San Jose's Olive program needed some more time in order to have a friend come and tow their vehicle away. So, time connected with assistance for repair or relocation is the type of reasonable accommodation request you can make. You can also ask for the vehicle if it does need to be towed. If I can't park here, can it be towed to a location where it can lawfully be, instead of towed to the storage facility, the private storage facility where they will be charged, $95 a day. Can it be towed to a safe lot or to a different lawful parking location, like, for example, a church that's offering that storage? Again, these are not ones where there's a lot of precedent, so you're probably going to get a lot of denials. But these would be very helpful accommodations. These are the types of accommodations that people need. Also, assistance retrieving property from a vehicle after a tow. You do have the right, if you can demonstrate that you own the vehicle, or depending on the policy of the particular storage facility, if you can demonstrate that the property inside the vehicle is yours, you may need assistance physically retrieving that property. And that's going to be true for people who have, mobility and other physical disabilities, as it is always going to be the case that they'll need help, lifting, carrying, and transporting materials, property. You could also ask for consideration of ability to pay. Everybody has a right under the California Vehicle Code to request a tow hearing within 10 days of the enforcement action. And there's no requirement, arguably, to consider one's ability to pay in those hearings, the fines and fees that would allow a person to retrieve the vehicle. But that is something that you can ask as a reasonable accommodation. I'm disabled, I'm unable to work, my income is SSI, and I'm asking you to consider my ability to pay and to reduce the fines and storage fees that are imposed upon me, for example. You can ask for exemption from enforcement. That's what we did in San Diego. We got no's, but as I said, that ended up being a long, hard fight that produced expensive relief for the class. And so it behooves a government to think about whether exemption from enforcement is worthwhile for people with disabilities who request it. And it could be narrow exemptions, for example, people who are undergoing active chemotherapy treatment, for example. This came up in the context of the San Diego litigation, may be allowed to park at least temporarily near the hospital so that they can access their treatment. So that's an example of another type of accommodation that I think is worth requesting. Next slide, please. Super fast, I'm just going to say this. In addition to the ADA, people with disabilities have rights under the Constitution the way that everyone does, and there may even be kind of heightened interests at play here. So the Fourth Amendment protects against unreasonable seizures of property. Next slide, please. And seizures like in sweeps, the taking of property, or in the context of a tow and impoundment, the taking of a vehicle are seizures under the Fourth Amendment. The seizures that happen without a warrant, as almost all of these are done without, are presumptively unreasonable unless some exception to the warrant requirement exists. Oftentimes, governments will point to the community caretaking exception, but that may not always apply. And ultimately, what a government's going to do if a person has lost property, like, for example, let's say, their walker, then a government is going to look at the nature and quality of the intrusion on the person's interest in that property. Like, I use that walker to walk and to move, and without having that walker, I cannot move. That's going to be a heightened interest that will be, balanced against the importance of the government's interest in seizing it. So, sweeps that result in just the crushing and impoundment of walkers, which happens a lot, is, at least nationwide, it happens a lot, is something that could certainly run afoul of the Fourth Amendment's protection against unreasonable deprivation of property. Next slide, please. And then accompanying that is we all have a due process, right? A government is not allowed not only to not unreasonably deprive us of property, they're not allowed to deprive us of property or liberty or life without due process. And next slide, please. At its base, what that means is a right to notice and an opportunity to be heard. And courts, again, use a balancing test to, weigh the interest in the for example, retaining the property. We use the walker example. So the interest of the person in retaining the property will balance it against other factors. But arguably, an interest in retaining something that you use to keep yourself mobile, healthy, or safe, or manage your disabilities is going to have a heightened interest and will weigh heavily against, for example, the interests of the government in efficient adjudication, meaning, the ability to just take the property. So we are at time. I see that Siri has to leave. Bye, Siri. But if there are any questions in this last minute, I see one. Does San Jose have any funds like San Francisco to reconnect families outside of city, state? That's a good question. I think what that question refers to are, funds that connect a person, like offers a person an ability to go from San Jose, for example, by plane or bus to a family member's home in a different state or area. And I know that there are programs that do offer that type of service, and I don't have enough insight to know whether San Jose specifically funds it or earmarks funding for that. But that does exist here. I'll point out that, some of what we're dealing with in the context of criminalization are really tight timelines. Like I said, 72 hours is like, that was a big win to get, 72 hours as the minimum amount of notice, and the ability to make arrangements to connect a person to get to another location where they are stable. It can be a massive challenge in 72 hours, even in the best of circumstances, and rarely are these enforcement actions occurring in the best of circumstances. It's usually, posting notice and the clock starts, rather than team of people coming out to do a meaningful encampment resolution and connect people with locations where they can be stable. And with that, I'll just say one last shout out, the Benioff, which is a part of the University of San Francisco, has encampment resolution guidelines and best practices that I highly recommend everyone check out. I can add it to the materials, so
Thank you.
hopefully Homebase can send it all out. But that describes a way that we can regulate public space, but also ensure that we're resolving encampments in ways that don't harm people further. And so I, definitely check out that resource. And thank you for your time.
Thank you.
I don't know if there are any other questions, but we are at time. I think a few people asked it earlier, and I'll just reiterate that the recording and the material are posted after this training, so you should have access to them. Thank you all for coming, and we can stick around for a few minutes if anybody has any questions.